legal updates that are impacting bargaining as we're coming up. So I think these are great topics today, Brian, and some of these came from some of our contractors from across North America. So with that, I'm going to kind of turn it over to you to give us kind of a little overview, and then we'll take it from there.
Yeah, that sounds good, Tony. And I think what would be helpful is I definitely don't want this to come across as a presentation per se. So if we can, feel free to ask questions, or if you see questions coming in, either politely or not so politely interrupt me, and we'll get down to it.
You bet.
All right, very good. So maybe what I'd like to first start with, and as Tony mentioned, we've got really three what I would call our primary topics for our conversation today, and that's number one, legal updates that may or will impact bargaining in 2026. We will also talk a little bit about what the economic forecast looks like and what we anticipate seeing from unions in connection with the current economic outlook. And then, as Tony mentioned, we'll take a look at or talk about so-called most favored nations clauses, and why that's something that, if you don't have them in your current collective bargaining agreements, why you might seek to negotiate them into your agreements, because they can provide some important protections for you and add some value. So I'm going to take them in the order that I just went through. And let's first start talking about some of the legal updates that will impact bargaining in 2026. And where I'd like to start is really to discuss briefly where things are at with the National Labor Relations Board. And just by way of kind of big picture and overview, the National Labor Relations Board is a federal agency that is responsible for formulating national labor policy. The National Labor Relations Board is responsible for enforcing certain labor laws that apply to unions and businesses across the country, and they can otherwise influence parties as a result of what the labor board is doing. And so the reason why this is important is that, and I promise that I won't get political, but when we talk about the National Labor Relations Board, we need to get a little political, because it is a function of politics. And given the fact that President Trump is in the White House right now, that has resulted and will result in a change in national labor policy. And the reason why that's important is that during the Biden administration, when the National Labor Relations Board was functioning, it was very employee friendly, very union friendly. And as a result, not surprisingly, unions caught on to this, and unions began being more aggressive in their negotiation tactics, their strategy, their organizing campaigns is really a result of knowing that the National Labor Relations Board would kind of quote unquote have their backs. So now that we're in a new era in the Trump administration, even though we don't have a current what's called a quorum, in other words, the National Labor Relations Board is missing a couple of participants, key participants, that we really need to have in place before the National Labor Relations Board can really get going and begin changing labor policy. But what it also means is that because the current National Labor Relations Board does not have the ability to officially issue decisions, what that can mean for employers is that you have the ability to frankly consider taking more aggressive positions in bargaining, in your approach to labor relations, knowing that the National Labor Relations Board, there's just such a backlog that that there are not going to be the consequences flowing as during the Biden administration. And then the last piece I'll mention is that the one thing President Trump has done is that he's appointed what is, very definitely a pro-employer general counsel. And what that means is that the general counsel is the chief officer who's responsible for enforcing the National Labor Relations Act. And as a result of a Republican Trump appointed current general counsel, the National Labor Relations Board is not being as aggressive. They're not going after employers the way that the general counsel was during the Biden administration. So maybe I'll pause there, Tony. I mentioned from the outset I didn't want to talk at everybody, but I just proceeded to do that for the last 10 minutes.
No, that's great, actually, Brian, and I think it's important there. I think there's misnomer about what the NLRB can do, and basically, from what I've heard you just lay out here, like many times, I've heard contractors over the years say, "Well, I really don't want this to go to the NLRB because it's not going to come down in my favor."
Right.
I hear the same things happen when it's we're going to go to mediation or arbitration because it's typically the unions that are keeping the arbitrators and people like that kind of employed to do those things. So people have been concerned about going to those places. Are you saying, at least I think what I'm hearing is maybe if you do have a legitimate issue, that maybe this is not a bad time to feel somewhat comfortable about letting it go all the way to the NLRB on this? Is that sound about right?
Yeah, and of course, any situation that you may face for which or an employer may face what are called unfair labor practice charges. We always want to be really careful about that and not be what's the right word, looking for a fight, so to speak. But the based upon the way that national labor relations policy is going to shift in employers' favor over the next minimally couple of years? The short answer is yes. I think employers can consider taking a more aggressive approach, carefully considered, of course. And I can say that I have my own clients who are really evaluating that as an option, because during the Biden administration, for better or for worse, I had clients that were really looking to stay under the radar, so to speak, and that is now shifting.
Okay. And I think, and I've been part of many conversations with contractors that just the idea of the threat of an unfair labor practice from the local unions gets them to be concerned and not want to go down that road. And even though it may not actually be an unfair labor practice,
Right.
but in the eyes of those who believe it is, that maybe it's worth the extra steps. Because at the end of the day, does it really hurt you to take something that you're in disagreement with to the National Labor Relations Board? Because if you just give in, you're going to get the same result, right?
Right. Yeah, I think that's a great point, Tony. And I what I would say is that the short answer is yes. And I think that when I talk about employers having an increased ability to be more aggressive, the reason why that's true is that you now have a national labor relations board and federal agency that is taking their direction from the administration and the current incumbent in the White House. So, and that being said, the Trump administration has made very clear that they are purposefully backing off of initiatives that were taken up by the Biden era. And so it's a long way of saying, to some extent, if you take something before the National Labor Relations Board, the cards are now going to be stacked more in your favor than they ever were before.
Yeah, and I think it's important. I'm sure everybody knows, but we got to make the point that FCA International, we are not promoting, as you said earlier, that we want to get
Right.
into these confrontations. This is more information again about if that's thrown at you and wait a second, this is not an unfair labor practice in my mind, from my legal counsel's perspective or anything. So okay, go ahead, file it. And we'll be happy to follow this through and see what the outcome is and maybe have a chance to come out successful on it. So, okay.
Yep.
Yeah.
And then one other piece before we move on to another issue in the legal development category is that, and again, with the understanding that my crystal ball only works about 50% of the time, if I could fast forward 2 years from now and ask the question to contractor or to employers rather, over these last 2 years, do you feel that unions were overall less aggressive than they were the previous 2 years? And I think the answer is going to be yes. So some of these changes in national labor policy is causing unions to be less aggressive in general, to be less willing to file unfair labor practice charges. I think they're going to continue to threaten them, but actually file them. They're smart enough to know that things are changing.
So, Brian, that does give me one more question then on this issue is what have you seen maybe prior to 2 years ago or even in the last 2 years? What are the kind of unfair labor practices that you're seeing the most of filed from labor?
Yeah. Uh, where to start? Everything. I mean, everything. And we're seeing, we saw a, a ton of unfair labor practice charges in the context of collective bargaining, alleged bad faith bargaining, where, the employers were being accused of, regressive bargaining or other unfair bargaining tactics. We saw unfair labor practice charges based upon employer policies and procedures like we had never seen before. So we saw challenges to certain types of employment agreements that we had never seen before. So, long way of saying, the National Labor Relations Board under the Biden administration really took what was considered to be an activist approach and really was trying to expand labor law in ways that were never intended.
Excellent. Great information. Thanks, Brian. I'll let
All
you.
right, so in the category of legal updates, I and this is just I'm going to have to be maybe somewhat more generalized given the audience, but we are going to, from an employer standpoint, we are going to continue to see an expansion of employee rights at a local level. And what I mean by local level is obviously federal law is the law of the land and it's going to apply to everybody. But what we're seeing is increased activity on a statewide basis. And again, I'm not getting political, but for those who operate in so-called blue states, you will continue to see expansions of employee benefits. And what I mean by benefits are paid time off benefits, meal and rest break type benefits, other forms of paid leave. In our state, for example, Minnesota, our legislature recently passed a law that provides for paid family medical leave. And the reason why I'm bringing this up is that with this expansion of various employee entitlements at a state and frankly even on a local level, there are counties and cities that are imposing requirements on employers. The reason why this matters for everybody is that number one, you need to be aware of these changes. Number two, as time goes on and as these local benefits keep expanding, you're going to have to make sure that your collective bargaining agreements are lining up with these various requirements, because oftentimes there are conflicts between the collective bargaining agreement and some of these local requirements out there. And depending on the state or the city or the county, sometimes there are collective bargaining agreement exceptions, but not always. So the takeaway is that you'll need to continue to pay close attention to state and local requirements that can impact your employment relationship with your employees, and obviously keeping an eye then on the ripple effect that may have to your collective bargaining agreements.
So Brian, let me ask you this on that issue then. So if I'm as a subcontractor come into an area and do work in a specific state or county, or even a city, and that area doesn't require me to license and to do that work in that area as a subcontractor. A lot of
Yeah.
areas do, but some areas still don't. But could I still be held to those standards if there's no requirement? as long as I'm meeting my CBA, even though I go into that city or the county and do
Yeah.
something, if I'm not required to have any type of registration, pay for a license or whatever to do business in that area.
Yeah, Tony, it's such an excellent question, and I wish I could give you a clear cut affirmative answer, but my best answer is it just depends. It depends on the county, the city, the state that you're operating in, because there are some states in the circumstances that you described that would not consider a subcontractor coming in under a what I'll call a blanket collective bargaining agreement or a master collective bargaining agreement to be a quote unquote employer as it relates to that state or city. There are other states and cities that may very well view that contractor coming in, even on a temporary or limited basis, as being an employer of that state. And I can speak affirmatively for Minnesota, and we have clients that, for example, have come into the state of Minnesota to work on a specific project for a period of 6 weeks. And in some instances, our state Department of Labor has taken the position that they just signed up to be a Minnesota employer, even though they were only operating for, again, a mere 6 weeks or so.
Okay. All right. Well, so that leads me to now two questions. If I'm in a state or city area where I'm negotiating, how much would we expect the unions to try to use those local requirements and try to get them into the collective bargaining agreement? And what kind of leeway do we have not to necessarily agree to whatever it is that the state or city locality is requiring there when it comes to the collective bargaining agreement. Hopefully that makes sense.
Yeah, yeah, it does make sense, Tony. The answer is that number one, um, oftentimes, I'll say sometimes unions are aware of these local requirements and will attempt to, sorry to be jaded, purposely mislead the employer into thinking that the employer needs to do more than they actually need to do. So it's always important to fact check whatever it is you're being told about a state or local or county requirement. Number two, they will often use the state or local requirements to and go one step further and demand more benefits, more time off, more meal breaks, more whatever it is, using that state or local requirement as kind of like a launch pad. So oftentimes they'll ask for more than what's actually required or demanded. Getting to your question though about how much or whether and to what extent an employer can resist some of those demands, it's really going to depend on the substance of that law, and whether there's sufficient ability to push back. And unfortunately, that given the world that we're living in, that patchwork of state, local, county requirements, it's just so variable. You really have to take a look at it on a state, city, county basis.
Okay. And I don't know if there is, but I'm gonna respond here on so currently right now to let the listeners know that there's on the signatory app that you can get on any app platform. Right now, within 3 clicks on that app, you can find out what the licensing requirements are for any place throughout the country. We'll look into and Brian we'll talk about this, but maybe we can find out maybe there is a place where they can actually find out whether it's a city, state, or county, what any of these new expansion employee rights might be, and we'll see if we can maybe give them resources for that. So, okay. All
Yeah,
right,
and
good
one thing
stuff.
too that and yeah, and I want to make sure that I say this in some of these laws, state laws, local requirements. Again, there are collective bargaining agreement exceptions that will say these laws or these requirements, so long as this employer is operating in agreement. So long way of saying it's really important to look at these requirements carefully and make a determination of whether there's an exception that could apply that would take you out of the purview of some of these requirements.
All right, perfect. Thank you.
Okay, moving on now, I'm going to shift gears here and talk about the economic outlook for bargaining. And, you know, I'll maybe start at a high level and get down to the practicality. So at a high level, some of the major indices that we're seeing are pointing to, you know, and again, maybe you've read this and heard this on the news, but you know, inflationary indices, consumer price indices, ranging between 2.8 to call it 3.2%. Really, and the takeaway there is that based on the economic projections that we're seeing right now and expect to spill into 2026, kind of that baseline level of inflation is expected to hover around that 2.8, 3 point something percent. And the reason why that's important is that unions are clearly aware of that information, and they will make the argument that, well, employer, you know, your wage increases, your, you know, benefit enhancements need to be well in excess of 2.8, 3 point something, 3%, because otherwise, you know, we're not making any progress. You know, we're not even keeping up with inflation. So again, and I think the comeback is, you know, ultimately, yes, inflation is a real thing, but that does not mean that you union get to come in and demand, you know, 12%, 18%, 30% over the course of a contract. And what I'm seeing is that despite the fact that all signals are pointing to decreased inflation or a stable level of inflation, I think you should consider or expect that unions are going to continue to make demands that we as employers think is outrageous. And that's, you know, that's no shocker. I can say that, and I negotiate contracts, of course, outside of your world, but I continue to have unions that are proposing, you know, wage increases and other enhancements that, you know, are double digit per year, which is just absolutely insane.
Yeah, how did you see it over the last year of negotiations? It seemed like we hovered around the 3 to 4% in different areas in the country, but did you see anybody make some bigger gains than those because of their starting off at such higher levels into double digits or anything like that?
Yeah, no, I would say that, you know, the average settlements that we're seeing are, and again, maybe a touch higher than that 4%, but I would say between, call it 3.5% and 5% generally. What I can tell you, Tony, is that we're not seeing the COVID related settlements that we were during that period of time. And again, a lot of this is, you know, industry specific, but across the board, that 3 to 5% range is really in the wheelhouse, I think.
Okay. All right. Well, that helps. We'll keep monitoring that as things change, right? Throughout, we got the midterm elections coming up. We'll see how that affects things. We've got interest rates, see how that stuff's going to go. But it's always a battle,
Right.
right? We always come to the table, and I'm not sure that many contractors go to the table and say, look, we got to try and reduce the wages, but we know the kind of increases that we start off that usually upsets everybody when we get to the table, and then typically it works out pretty well from there, but takes a while. So, any other
Right.
insights on that from the economic outlook?
No, except that I will say with great confidence that, you know, we are past the COVID era or the COVID settlements. You know, I've negotiated some contracts that, you know, were expiring last year, and we still had some what I would call COVID ripple effects, but that momentum has seemed to fizzle, and I think employers can expect more, what I would call our traditional wage settlements with the unions.
Yeah, I don't, but doesn't it seem like too, going back to a little bit of what we talked about a few minutes ago with the expansion of employees' rights and paid time off, paid leave, it almost seems like the push now is how can we get paid for not working? And that's not
Yeah.
what I mean, but the hours that we don't work, right? Because we struggle in different areas too, depending on the agreements. Where we have contractors who, paid their people during COVID. Um, they weren't working, but kept the pay going for them, but yet, and then got maybe hit because they didn't pay the funds and they were required anytime they paid an hour to pay the funds. So, I think contractors typically have no problem with paying for work being done, but we're kind of going into this transition of, what people deserve and how can we afford that, right? It's not that
Right.
contractors probably in a sense don't feel they don't deserve it, but how do you afford it if the customer's not paying for it, right?
Right. Right. That's exactly right. And I would also say too that and I know I'm stating the obvious, but to the extent that you employers out there are faced with these various state, local, county requirements, um, in my best Minnesotan, you betcha those add up in terms of cost. I mean, that's all part of the economic pie that we have to work with when we negotiate contracts. So the fact that the state or city or county may require you to provide certain types of benefits, that's not just free money. That's costing you real money that needs to be factored in when you're negotiating with these unions. And at the end of the day, if you are in a state or city that does impose requirements upon you, it very well may be the case that the union walks away with a 2% settlement because of those added costs that are built in.
Sure. Yeah, the difficulties of the mindsets are real, right? And everybody's looking at it from a different perspective. So, well, tell us how we can save ourselves with this most favored nations clause. I
Yeah.
see around the country, actually, we're starting to track this. And I was actually surprised. We have right now, I would say, more contracts that don't have this than do.
Okay.
And the reason I think that surprised me is because with one of the unions a few years back, we did a model agreement, and that model agreement, which was put together through labor and management, had a most favored nations clause in it. And we just recently got one added to a CBA that we were involved with in this last negotiation cycle. And the local union didn't really have a problem with it, and got it put in pretty easily. But we've had other areas where they just want nothing to do with it.
Yep.
I think that
Yep.
should raise a little bit of a red flag, but I'll turn that over to you now and kind of give us some insight on why this is important, what should we do, and how much should we actually fight for this, and what rights do we have to
Yeah.
get it in there?
Yeah, no, yeah, and great topic. So just by way of level set, just so that we all know what we're talking about, and I'm talking in generalities, but a most favored nations clause it's contract language that basically says to the union, if you go out and negotiate a different deal or a more favorable deal with some other employer, and let's just say you negotiate a rate that's $1. I'm making this all up, but $1 less per hour. You union have an obligation to A, let us know about it, if we have the right contract language, and B, we get to match that more favored rate or those more favored contract terms. And so, at a very, very high level, it's a mechanism by way of the contract that enables you, or maybe more accurately, provides you with a great level of protection to make sure that the union's not going to undercut you by going and brokering a deal with some other employer that puts you at a competitive disadvantage. And so and I know maybe the effects are obvious, but if you can negotiate into a contract, if you don't have a clause like this, it really can help you and make sure that you have that level of protection. And I don't mean this to sound the way it's going to sound, but it keeps the union honest and making sure that the 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 wages and benefit packages and the other terms and conditions of employment are fair, and you're not going to be left in the dust, so to speak. Because, you know, without a favored nations clause, you could find yourself in a position where you've got one of your, you know, effectively one of your competitors was able to broker a better deal, and you're stuck with the worst deal. And from a competition standpoint, that puts you in a tough spot. So, you know, the one of the features that we like to see in a most favored nations clause, and what ends up sometimes biting employers, is that there's a favored nations clause in the agreement that operates, we'll call it effectively, but in a perfect world, we would also get contract language that forces the union to notify you, the employer, if they have brokered a more favorable deal. So it puts the responsibility on the union to affirmatively let you know. Because I've had clients in certain circumstances have this language, and for a variety of reasons, they come to find out a year or 2 or 3 years later that the union has been violating this clause. So that's why that notification piece is really helpful if you can get it. To your question, Tony, of how hard do you fight for it? You know, obviously there's a whole bunch of dynamics that impact collective bargaining, and depending on the contract and the contract cycle, you may have certain priorities that are more important than a most favored nations clause. But I would begin going after it as aggressively as you're able. Whether and to what extent it's going to, you know, hold up a deal or blow up a deal, you know, I think that just has to be based on, again, your individual circumstances and how much you're willing to fight for it. But this is one area where, you know, the benefits are so important, and the protections that these clauses provide are so important that I would make it a high priority issue.
Yeah, and I do think they're in such union heavy areas enough around the country that if you're trying to get it, I think it's relatively easy. It just takes some effort because in some cases we found out, especially in some of the smaller areas, the unions weren't even that familiar with it. Some of the agents weren't familiar with it, but
Sure.
most of them actually are. And just to be clear, Brian, you talked about, you know, a dollar more, but most of the time we see this that its language is just as, or if not more important. Like they might sign
Right.
up a new contractor and say you can work 4/10s to where your collective bargaining agreement doesn't allow you to work 4/10s,
Yes.
or that you can
Yes.
do a Saturday makeup day and your contract doesn't allow you to make, you know, it's kind of a thing we all know this is people in sales. You've got a customer who's been buying from you for years, and then you're trying to get a new customer, so you give them better pricing to try and bring them in, right?
Right.
And the whole
Right.
idea is that we're partners with our labor partners, and we just want to be make sure that we're not having an unfair playing field on this. So language is just as important, and we'll make sure we get some language out to everybody too. So anything else on that though?
No, and I'm glad you brought that up, Tony, because you're absolutely right that it's oftentimes these clauses are extremely important because of the direct financial impact. But what you just described, you know, working 4/10s or some other, you know, adjustments to scheduling, or again, as the name would suggest, any other more favorable terms, you want to make sure that you have access to those more favorable terms, because again, it can put you at a disadvantage.
Sure. And where does this fall? Let everybody know when it comes to mandatory subject of bargaining or not.
Yeah, that's a great question. You know, there's a, and I'm hemming and hawing and pausing because the law has shifted back and forth on this. But generally speaking, it would be, because it can ultimately impact terms and conditions of employment. My position is that these are mandatory subjects of bargaining. So you may get a union that's going to tell you otherwise, but my position is that it is.
Okay. All right, great. Well, awesome, Brian. I think we did a good job of covering this, and I think we've kind of gone through it pretty thoroughly. I'm looking forward to next month. We're going to talk about understanding industry contributions and contractors' rights with labor funds, management funds, and labor and management funds. So I'm looking forward to that too. But in wrapping up, is there anything additional based on these three topics today that you want to share with anybody before we sign off here?
No, not from my standpoint. I agree. Despite what I said, I feel like I talked a whole lot.
It's fantastic, though. I think we got great information here, and it's been good. So I appreciate your time today, and I look forward to our discussions next month. Thank you very much,
All right.
Brian. Appreciate you.
Yep, very good.
Take care.
Yep. Take care.